Hi everyone. In the previous classes, in the subject business law, we have discussed about the contract, then Companies Act and the other important chapters. But now we are going to discuss another important chapter called Partnership Act, Negotiable Instrument Act. So there are two important acts we are going to discuss: Negotiable Instrument Act 1881, Partnership Act 1932. So now the Negotiable Instrument Act, as per Unit 3, which we are going to discuss: nature and requisite of negotiable instrument, transfer of negotiable instrument and liabilities of parties, holder in due course, discharge of negotiable instruments. Now the Partnership Act 1932, meaning and characteristics, formation and registration, rights, duties and liabilities, and dissolution. Now before starting, the Negotiable Instrument Act 1881, the negotiable means transfer. Instruments are called as promissory note, bills of exchange, then check. Promissory note deals with section 4, bills of exchange deals with section 5, and check deals with section 6. Now these three are negotiable instruments, but at the same time there are other customary payment methods similar to negotiable instruments in our country, but this law which is not used to cover. Say for example, handis. So these type of customary payment methods which we are not following, but as per this Negotiable Instrument Act, we are going to discuss what is meant by promissory note, bills of exchange, and check. Now what are the major characteristics of negotiable instruments? The point number one, as I told, the instruments, the promissory note, bills of exchange, and check, it must be in writing. It must be in writing. And second point is signed by the maker or drawer. The same instruments are required to be signed by the maker or drawer. Second point. Third one is unconditional promise to pay. Unconditional promise to pay. State a fixed amount of money freely transferable from one person to another person, either the instruments payable on demand or some definite period of time. At last, the instruments payable to order or to bearer. Now, as per section 13 Negotiable Instrument Act 1881 states that the negotiable instruments means promissory note, bills of exchange, or check are either to order or to the bearer. Now, the another important point: what are the various presumptions which are required to form the negotiable instruments? First one is consideration. So what is meant by consideration? Every negotiable instruments was made, drawn, then accepted, endorsed, or transferred for consideration. So there are four important points. Every negotiable instruments which are required to be drawn. Point number 2 should be accepted by the party. Point number 3, endorsed, or the last one is transferred. Another second point, not only consideration is important, every negotiable instrument bearing a date was made or drawn on such date. So date which is important, and at the same time the time of acceptance, that every bills of exchange was accepted within a reasonable period of time after its date and before its maturity. And transfer, every transfer of negotiable instruments was made always before maturity. Now the other important point, time of endorsement. Endorsements appearing upon a negotiable instrument were made in the order which may appear. Then stamps, promissory note, bills of exchange was duly stamped including check. So promissory note, bills of exchange or check was duly stamped, but at the same time that we have to know some major important point, holder and holder in due course. So what is the difference between holder in due course, which we are going to discuss later. But at the same time, again another important point, dishonor. If the instrument was dishonor, okay, now a suit upon a dishonor instrument was filed with the court and the fact of protest is required to be proved. So dishonor of instrument also another important point which we are going to discuss. So far we have discussed about the various characteristics for consideration. Date is important, time of acceptance is important, transfer is important, time of endorsement is important, stamps are required to mention or to use in the various instruments, holder in due course, last one is dishonor. So these are the presumptions of negotiable instruments. Now the second heading is transfer of negotiable instruments. Negotiable instruments can be transferred on two bases. One is assignment or negotiation. See, negotiation means negotiable instrument act which are required to transfer from one person to another person. For that we have discussed check and promise note and bills of exchange. Okay, what is meant by assignment? Assignment which comes under property which are required to be transferred. For that the separate act is called as Transfer of Property Act 1882. So negotiation which comes under NI Act, Negotiable Instrument Act, and assignment which comes under Transfer of Property Act 1882. So effect of transfer, how that we are going to transfer these negotiable instruments. Assignment means the transferee has the rights of the assigner. Simple, the transferee has the rights of the assigner. But negotiation, when an instrument is transferred, the transferee becomes a holder. When I am transferring my rights to you by signing in the instrument under Negotiable Instrument Act, the person holding the instrument in his name is called as holder. Okay. So these are various important points which are required to be known under effect of transfer under what? Negotiable Instruments Act. But for that I have told the transfer which took place in two ways. One is assignment, another one is negotiation. Then what is the difference between negotiation and assignment? The negotiation which comes under NI Act, Negotiable Instrument Act 1881, but the assignment which comes under Transfer of Property Act 1882. In negotiation, the person who transferred, the transferee will become the holder under NI Act, negotiation. Assigner, payment of debt by one person to another person. Okay, so under assignment, the payment of debt which is required to be paid by one person to another person. Here in the negotiation, transfer of negotiable instrument only, but assignment can be made by any right. There is no such restriction, but here transfer of negotiable instruments only means the promissory note, bills of exchange, check. But the another important point, bearer instrument. What is the meaning of bearer instrument? Just a delivery. Bearer instruments, delivery, and order instruments. Okay, so here under Negotiable Instrument Act, the bearer instruments, the delivery and order instrument means endorsement and delivery. So both are presented. Bearer instrument only for delivery, order instrument, endorsement and delivery which are presented in the negotiation under Negotiable Instrument Act 1881. But what about assignment? Assignment made in writing which is signed by the assigner when it is required to transfer the property or made of debt by one person to another person. But in negotiation, no notice is required. No notice is required while transferring the negotiable instruments. But here, notice is required. In assignment, notice is required. In negotiation, without consideration, without any consideration, can be transferred the instrument. But the assignment, consideration is very much important. In negotiation, the person, those who holding the instrument, okay, may have a better title, But here in assignment, no such better title. In negotiation, no stamp duty is required to pay. While transferring the negotiable instruments, no stamp duty is required to pay. But here, since you are transferring the property, whereas you have to pay the stamp duty, that which is called as what? Assignment. So there is a difference between negotiation and assignment. So what are the headings which we have discussed in while seeing the difference between negotiation and assignment? Negotiable Instrument Act 1881, Transfer of Property Act 1882. Point number 2, holder of negotiable instrument. Here payment of debt by one person to another person. Here transfer to negotiable instruments only. Here assignment can be made by any person. Here bearer instrument and order instrument. Bearer instrument is delivery, order instrument means endorsement and delivery. But here in assignment, made in writing and assigned by assigner. No notice is required in negotiation, notice is required in the assignment. Without any consideration under negotiation, consideration is required in the assignment. Holder in due course having better title under negotiation, no such better title in the assignment. No stamp duty is required to pay, but here stamp duty is required to pay. So these are the various differences which I used to cover to know under negotiation and assignment. So what are the various classification of negotiable instruments? So first one is order instrument. So what is the meaning of order instrument? Order instrument means a negotiable instruments paid to a particular person only. If they are going to order paid to X only, then it is called as order instrument, particular person. Bearer instruments payable to the order or the bearer. Okay, so the person possessing a bearer instrument means the person who is holding the instrument, payable to the order of bearer. Example, pay cash or paid to the order of cash, paid to X or bearer. Okay, paid to X, only if they mention paid to X, then order. Paid to X or bearer of the instrument. So, who is called as bearer? One who holder. Okay, one who is the holder or possessor of an instrument that is negotiable. So, whoever person who holding the instrument, okay, or the possessor of an instrument that which comes under negotiable, it is called as bearer instrument. So, what are the various types of negotiable instruments? As I told already, the promissory note, bills of exchange and check. There are three important negotiable instruments. Then what is meant by holder? Okay, the holder means the person, one who holding the instrument, right to recover the money in his own name, called as holder. A holder, he must have the possession of the instrument. He must hold the possession of the instrument. Not only possession of the instrument, also right to recover the money in his own name is called as holder. Now, what is the meaning of holder in due course? Say for example, maker or drawer of negotiable instrument. Next point, payee or bearer of the instrument. Then again transferring the negotiable instrument, holder in due course. Point number 1, holder, one who takes a negotiable instrument for a value in utmost good faith without noticing of defect. The instrument bears apparent evidence of forgery, alteration or irregularity. All these are all called as characteristics of holder in due course. Say for example, A is a payee for a valuable consideration of bills of exchange payable to order. He gets this instrument from B. A gets instrument from B without knowledge of any defects in B's title and its maturity. So A is a payee for a valuable consideration of a bill payable to order. He gets this instrument from whom? He gets this instrument from B, but without knowledge any defect in what? B's title and its maturity. Now here who is called as holder in due course? A is called as holder in due course. Why? Point number 1, one who holding the instrument. Point number 2, A is taking that instrument. Instrument what here? Bills of exchange. It's a negotiable instrument. Point number 3, for some value. Point number 4, utmost good faith. A is having the utmost good faith in B without noticing the defect. Okay, here I mentioned one important point. B without knowledge of any defect. Okay, E gets this instrument from B. A gets this instrument from B, but without knowledge of any defect in what? B's title and its maturity. So the fifth point is without noticing of defect. Now the last one is the instrument bears no apparent evidence of what? Forgery, alteration or irregularity. If all these conditions are satisfied, now as per this example, A is the person one who called as holder in due course. So holder means the person who holding the instrument. Holder in due course means from A to B, B to A, and again the another party C. At last C is the person who holding the instrument. He received the instrument from the various parties. C is the person who received the instrument from B. B received the instrument from A. But at last C is the person who holding the instrument is called as holder in due course. The reason is all the prior parties are liable to A. All the prior parties are liable to A. It's called as what? Holder in due course. Now section 4, promissory note. So what is meant by promissory note? Promissory note, it's an instrument in writing. It is not a bank note or currency note containing an what? Unconditional undertaking. Point number 1, instrument in writing. Point number 2, unconditional. If there is a condition, then it is not called a promissory note. Signed by the maker to pay a certain sum of money only. Signed by the maker to pay a certain sum of money only, order or a certain person or to the bearer of the instrument. Order means I have told already particular person. Bearer means paid to X or bearer. Then it is called as bearer instrument. Okay, so promissory note. The next one is, what is the difference between bills of exchange and promissory note? See, in the bills of exchange, creditor is the drawer. But in the promissory note, debtor is the drawer. The most important point while analyzing the difference between promissory note and bills of exchange, debtor is the drawer in promissory note, but here creditor is the drawer in bills of exchange. Point number 2, in promissory note, promise to pay. I promise to pay. Then it is called as promissory note. I promised or undertaking. Then it is called as what? Promissory note. Order to pay. It is an order to pay. Then it is called as bills of exchange. In promissory note, it needs acceptance by the drawee. Drawee should give the acceptance. There are two types of acceptance. One is general acceptance. Another one is conditional acceptance. Okay, when the person is asking the drawer one who given the acceptance immediately, then it is called as general acceptance. In case if he has not given his acceptance, if he says that after selling the goods that he will come forward to settle the amount, then it is called as conditional acceptance. There are two types of acceptance which are used to prevail in promissory note. Next one, how many number of parties are there in the promissory note? Promissory note, only two parties. One is promisor, another one is pay. One is promisor, another one is pay. Okay, so as I told, acceptance which is required in bills of exchange by the drawee. Okay, but here promissory note, acceptance, it does needs what? Acceptance by the drawee, but in bills of exchange alone the acceptance are two types. Okay, one is conditional acceptance, another one is general acceptance, another one is there are two parties, promisor and pay in bills promissory note, but in bills of exchange there are three parties, drawer, drawee and pay. There are three parties are presented in the bills of exchange. Always drawee should give the acceptance. Okay, so that's why in bills of exchange are three parties, but in promissory note only two parties. Promisor has the primary liability to pay in promissory note. Okay, when we are discussing about liability of parties in promissory note, okay, the promisor has the promissory liability to pay. Which party one has given the promise, okay, he should come forward to make the payment to the party, called as promisor as the primary liability. But in the bills of exchange, liability of the drawer arises only if the acceptor does not pay. The person who has given the acceptance, okay, if he failed to make the payment, then only the liability of the drawer will come to pay. So there are two differences. Okay, here promisor has the primary liability to pay. Here liability of the drawer arises only if the acceptor does not pay. In this case, noting is necessary. Sir, noting is necessary in which instrument, whether bills of exchange or promissory note, means promissory note noting is necessary. But what about bills of exchange? In case of dishonor, it is better to get it noted or protested for non-payment. So both noted or protested for non-payment, which is used to present a noting or protesting presented in the bills of exchange. Only noting is presented in the promissory note. Then the next one is number of copies. See, only one copy is prepared, whether it is foreign or local, in the promissory note. Only one copy. But in the bills of exchange, in case of foreign bills, 3 copies are made. Otherwise, only one copy is enough. But for the foreign bill means 3 copies. Promise note stamped in any case. But here, bills payable on demand need not to be stamped. But otherwise, stamps would be necessary. In case if the bills are payable on demand means need not to be stamped. So there are 2 important classifications. Promise note bills of exchange. First one is drawer. Second heading is order and promise. Third one is acceptance. Fourth one is parties. Fifth one is liability. Sixth one noting and protesting. Noting is presented in promise note. Both the noting and protesting presented in the bills of exchange. Copies, only one copy is enough in the promissory note. But in case foreign bill means there are 3 copies are required. Last one is stamped. Stamped, as I told, stamped in any case it is required in the promissory note, but bills of exchange payable on demand means need not to be stamped. So these are the points which are required to be noted when we are understanding the difference between promissory note as well as bills of exchange. So what are the essential points of promissory note? It must be in writing. Okay, so writing may be and any paper or book. A oral promise to pay does not become a promissory note. Another one is, say for example, I promise to pay B or order of rupees 500. Okay, I promise to pay B or order of rupees 500. It is called as promissory note. Second point I have told already, undertake to pay. Okay, undertaking to pay. Contain, it must contain a undertaking to pay or promise to pay. Okay, then the promise to pay must be unconditional. Say for example, A signs the instruments. Okay, I promise to pay rupees 500 7 days after my marriage with C. Here condition. Then it is not called a promissory note. As we have discussed already, promise note must be a unconditional. It should be signed by the maker. Promise to pay money only. Say for example, I promise to pay rupees 5,000. Instead of that, you just give your watch. It is not a promissory note. Okay, promise to pay what? Only money. Instead of that, the party doesn't have right to get any other thing except what? Money. So promise to pay money only. Promise to pay a certain sum of money only. I promise to pay B rupees 1,000 and all other sums which shall be due to him. Not a valid promissory note. Okay. So in the 1,000 rupees, let I will pay rupees 500 now. The balance amount which will be paid later. It is not a valid promissory note. And at last the stamping which is required in the promissory note. Now bills of exchange section 5. So what is meant by bills of exchange? It's an instrument same unconditional order signed by the maker, directed to a certain person to pay a certain sum of money, order certain person or the bearer of the instrument. But here there are three parties. I have told already there are three parties. Okay, say for example, X purchased goods from Mr. Y rupees 10,000. Mr. Y buys goods from Mr. S for the same amount of 10,000. So totally three parties. Now what will happen? Y may order X to pay the 10,000. Okay, X to pay rupees 10,000 to Mr. S. Now this will be called as what? Bills of exchange. So totally there are three parties. One party should give the acceptance. Okay. Same way, already we have discussed, there are various essential points which are required to be presented in the bills of exchange also. Okay, it must be in writing, contain an order to pay, order must be unconditional, signed by the drawer, drawee and payee. A bill cannot be drawn on two or more drawees. Sum payable must be certain amount. The bill must be contain an order to pay money only. At last, there are certain legal formalities. Date is important, consideration is important, and the stamp is also required. Last one is section 6, check. Check also is kind of a bills of exchange, but it has added some additional qualification. In check there are certain additional qualification. The check should always drawn on specified banker. Point number one, only specified banker. Another one is payable on demand, but there is no grace days. But in promise note, bills of exchange, you may have some grace days, but for the check, there is no grace days. Already the check validity period, since they are given for 3 months, so they have to deposit the check during this period. So that's why they have not given any grace days for the check. An electronic image of truncated check, it is called as paper check. Okay, paper check truncated during a clearing cycle, signatures in ink. Last one is a check in a electronic form. So check in electronic form means what? It should contain a digital signature. Even there are certain characteristics of check. Must be in writing, same order to pay, unconditional, signed by the drawer, certain sum, pay money only, but drawer, drawee and payee must be certain, always payable on demand. It contains all the characteristics of bills of exchange, but doesn't require stamping or acceptance. In check, it doesn't require stamping or acceptance. Earlier, you know very well, the validity period of the check earlier is 6 months, but later, as per RBI notification, 4th November 2011 onwards, this 6 months has been reduced into 3 months. Okay. And the next one we have already discussed about the liability of parties, primary liability as well as secondary liability. In the promissory note, the promisor, okay, is the person who comes under what? Primary liability. But in the bills of exchange, okay, the bills of exchange, in case the drawee who failed to give his acceptance, then only the drawer will become the primary liability. Otherwise, the drawer will become only a secondary liability. The drawer, since he has given the acceptance, he will become the primary liability. So liability are two types. One is primary liability, another one is secondary liability. Okay. Now the discharge of parties. How they can able to discharge the parties? Okay. The first one is cancellation. If the holder cancels the name of any part on the instrument, I am the person acting as a holder. If I cancels the name on any part on the instruments, okay, the party whose name is cancelled, okay, shall be discharged. So which party name which I cancel will be discharged. Okay, it is called as discharge of parties. Second one is releasing. If a holder release any part on the instrument, point number one, holder cancels the name of any part on the instruments, only the name. Point number two, it says that, okay, point number one, cancel party. Point number two, releases any part on the instrument. Okay, the party who is released, okay, the party subsequent to such released party also shall be released. If the holder releases on any part on the instruments, whereas the subsequent parties also what will be released. This can be comes under a concept called discharged. Point number 1, cancellation. This is an activity. Okay, so for that cancellation activity, the party whose name is cancelled, subsequent parties also cancelled party shall be discharged. Point number 2, release. If the holder release on any part of the instrument, at the same time the party who is released subsequent to such party also shall be discharged. Point number 3, payment in due course. If any party pays the amount in due course, the party who made the payment, the subsequent to such paid party also shall be discharged. So 3 important points which we need to remember. One is cancellation name, other subsequent parties also will be cancelled. If a holder release on any part of the instrument, the subsequent the party as well as subsequent party also shall be discharged. And point number 3, payment in due course. Okay, pays the amount. If any party pays the amount on payment in due course, the party who made the payment, not only the party who made the payment, the subsequent parties to such payment also shall be discharged. Okay, so cancellation is one of the activity, release is the second activity, and payment in due course is the another activity. So these 3 are the major activities which we need to remember while discharging the parties or the discharging of the instruments. And the next important content Partnership Act 1932. So before, while starting this Indian Partnership Act 1932, in the Negotiable Instrument Act 1881, we have discussed there are various concepts. Point number 1, definition of Negotiable Instrument Act. Point number 2, we have discussed about the characteristics of negotiable instrument. Then the third one, the difference between promissory note and bills of exchange. Then the fourth one, the characteristics of negotiable instrument, the characteristics of promissory note, bills of exchange, check we have discussed. Then the difference between negotiation and assignment. In check again there are important types called as crossing. Another important concept in the check where we are drawing 2 transverse parallel lines in the instrument, it is called as check. So when you are drawing 2 transverse parallel lines in the instrument, it is called as what? The crossing. Okay, this crossing is very much important to avoid the fraudulent activities. Okay, whoever the parties, those who are going to issue the check, they should draw 2 transverse parallel lines in the instrument. So it is easy to protect the person while issuing the check. In case if the check got stolen or else someone has taken that check, they cannot present the check in the bank since the party owner crossed. So in this crossing itself, what they will do, they can write upon pay. Okay, they can write upon pay, only amount can be paid only to that particular person, not to anyone else. Upon pay or the bank name. Okay, bank name, then the amount which we go to only to that particular bank and to that particular person. So likewise, whoever while dealing with in issuing the check, the parties may have right to know about the various types of crossing. Okay, in all the instruments, even the bills of exchange, promissory note, but especially in check, to protect your rights, this crossing is very much important. Even the dishonor of check, section 138 to 142, which says that immediately once the check got dishonored, when the check got dishonored due to insufficiency of funds, the check might be got dishonored. Let the party who received the check, if the check got dishonored, immediately need to approach the advocate and asking him to send a notice to the party to deposit the amount within specific period of time. But even after sending the notice, if the other side, the party who not given any importance in depositing the amount, later now the party holding the cancelled check with all the other documentations, he may have right to file the suit in the court. So dishonor of check especially it is coming under criminal offence, whereas party want to issue the check. If the check got dishonor, the party which need to go under punishment. But at the same time, in case after issuing the check, if he knows very well there is no sufficient funds in the bank, immediately the party want to issue the check may instruct the banker to stop payment. This provision is applicable, or else he can request the party no need to deposit the check since there is an insufficiency of fund. After giving the instruction, please go and deposit the check to get the money. So here dishonor of check also very much important. So promissory note, bills of exchange, then check, noting, assignment, discharge of parties, who is called as holder, who is called as holder in due course, order instruments, bearer instruments means paid to X, or bearer is called as bearer instruments. Okay, all these points what we have discussed, as I have mentioned here, which comes under Negotiable Instrument Act 1881. Now Indian Partnership Act 1932, as Section 4 of Indian Partnership Act says that a partnership is a relationship between two or more agreed to share the profit carried on by all or any of them acting for all. So here, since we are discussing about partnership 1932, but above when we are discussing about Indian Partnership Act 1932, that I need to have a quote, the another important act. Okay, Limited Liability Partnership Act also, which is very much important. In the recent days, most of the people are showing the interest in doing the registration, especially comparing with Indian Partnership Act. Okay, LLP. It is very much important type of business concern in the recent days as per LLP Act 2008. Okay, now there are vast difference between Indian Partnership Act 1932 as well as LLP Act. Okay, but since we are discussing on Partnership Act, there are various features which are required to know. One is agreement is very much important. It is called as partnership agreement. Okay, but without agreement, partnership cannot be formed. The agreement may be in written or oral, but it must be written means can able to settle the disputes. Always for legal point of view, instead of presenting the oral information, written statement which is very much important in order to settle the disputes between the parties. Second one is registration. It is not necessary that a partnership may be registered, but in case of registered firm, many problems can be created. So that's why in case of registered firms, okay, so they can be able to resolve certain things, but here partnership, it is not necessary to register, but while doing the registration there are various issues easily can be able to resolve, and at the same time there are certain issues may also chances are there to rise. But in a partnership, okay, there should be at least two partners. Ordinary business, the partners not to exceed 20, but in banking business not more than 10. Profit and loss distribution which is required. Unlimited liability. The liability of the partner is not limited to his invested amount. In case the loss, even the private property of the partner also used to pay what? To the business organization. So here unlimited liability, but there limited liability partnership. Okay, so why the people are showing interest with the limited liability means, okay, their personal assets need not to what settle, but here the including the personal assets which are required to settle in the Partnership Act 1932. Okay, so law has not granted in any legal entity. It is not an independent from the partners. Okay, it has not separated entity from its members. It is separate legal entity called as separate. So how you are going to form the partnership? Okay, so previous points we have discussed various features. Point number 1, agreement is important. Point number 2, registration is important. Point number 3, number of partners. Then fourth one, profit and loss distribution. Then object of the business. Okay, then unlimited liability. And the last one is entity. Then the formation of partnership. How they are going to form the partnership? Partnership agreement, which is very much important, but in that partnership agreement, what are the various articles of partnership is required? Now, name of each partner, name of partnership, then the duration of partnership, how profits are divided among the partners, as we have discussed in the characteristics, profit and loss distribution, division of management responsibilities, since there are various types of partner, active partner, dormant partner, sleeping partner, okay, partner in profit only, partner by estoppel, partners by holding out. So there are various types of partners. So divisions of management responsibilities which are required, what type of partners comes under the responsibility, and contribution from each partner also required. So there are certain important articles to be presented in the partnership agreement: name of partnership, duration of partnership, then how profits divided, then the division of management responsibilities, contribution from each partner. Then the next we are going to discuss registration of partnership business, how they are going to do the registration, especially partnership business. Name of the partnership business is important. So when you are giving the name, the address of the head office also very much important. Just like that, we cannot give the name, the address of the head office also is important. If there is any branch, then branch business address also, which is very much important. Purpose of the business, what is the major purpose of the person who want to do the business, the purpose which is required, starting timing of the business, partner's name, address and occupation, joining date of each partner in the partnership business, and duration of the partners. So all these points again which are required to be presented in case the partners, those who want to do the registration of partnership business. So previously we have discussed about the characteristics, and the next one is the registration of the partners. Now rights of the partners. So what are the various rights where the partners are having while doing the partnership business as per Indian Partnership Act 1932. Point number 1, each partner may have right to take part in the management, okay, while doing the business, and even they may have right to what? Inspect the books of accounts of the firm, and they may have right to get the copies, right to be consulted. Every partner may have the right to consulted and heard before any matter is decided. Just like that, a partner doesn't have right to take the decision, he need to get the consultation from the other partners also while taking the decision. Then right to share profit. Okay, every partner has a right to share profits equally earned by the firm, irrespective of his amount of capital contribution. Right to collect the debts. Even here, a partner has an implied right to collect partnership debts and to give receipts for payments. Right to act as an agent. See, partnership always it's a relationship between principal and agent. Every partner is an agent for the other partner. Every partner has act as an agent on behalf of the remaining partner and bind the other partners to his act. Rights of retirement. Every partner has a right retirement from the firm with the mutual consent of all the partners. So just like that, he doesn't have right to retire from the firm. He need to get the consent. Okay, so mutual consent of all the partners which is required. But when the partnership is at will, okay, we can leave the firm at any time. Okay, so there are two times. If the partner one showing his willingness to leave means that he can leave at any time. But at the same time, for the retirement means the mutual consent is required. But anyway, they have to give the due notice of his retirement from the firm. So any partner those who decided to retire need to get the mutual consent, but at the same time partnership at will, he need not to get the consultation, let he can leave, but what they have to do? They have to give a notice. Okay, so the due notice is very much important. Right of competing business. An outgoing partner, a partner who retired, outgoing partner may have right to start a business competing with that of the firm, but he cannot use the name of the firm. He may have right to do the same business, but he don't have right to use the name of the previous business, okay, previous company or previous partnership. Okay, so it is very much important. He may have right to do the competing business, but at the same time he don't have right to use the name of the firm. So what are the duties of partners? So in the rights of partners, right to take part in the management, right to inspect books, right to be consulted, right to share profit, then right to collect debts, right to act as an agent, right of retirement, right of competing business. Now duties of partners. The partners who need to work for common advantages. There should not be any discrimination among the partners, where their common advantages they have to get the profit. To reach the profit, every partner they have to work as a common. And next one is, among each partner, the faith, which is very much important. Without knowing to the other partner, the partner doesn't have any right to take any secret profit. Then they have to submit true accounts. Each partner they have to submit what? True accounts, and to indemnify for fraud, not to claim remuneration, and to share both profit and losses. At last, to act with authorities given. So whatever the authorities given, as I told, active partner want to actively take part in the business, sleeping partner want to not take part in the business, partners in profit only want to use to take only the profit. Okay, so likewise there are various types of partners. So whoever the partners want to given some authority, they should act the authority what they are given to them. Relationship of partners to third parties. So previously we have discussed about duties. Now how the relationship partners to the third parties, which is another important point. The partners will be bound by each other's action on the basis of an agency relationship. So it's a relationship between principal and agent. So while the relationship of partners to third parties, there are certain points. Point number one, the transaction within the scope of the business. Within the scope of the business. Point number two, the transaction has been effected in the usual way. Point number two, the transaction has been effected in the usual way. Point number three, third party involved in the transaction. How the third party involved in the transaction? Either, okay, point number one, knows or believes the partner is acting as a partner. The third party is one who knows very well the X is a person who is acting as a partner. Now he may have right to what? Create some good relationship with the partner. Or else, unaware of any lack of authority. It includes even the non-partner who is believed to be a partner. Sometimes there are two partners. Just like that, he is asking, he is also acting as a partner, but when he maintains silence, he is not giving any answer to me, saying that what? He is not acting as a partner in the firm. Since he was maintained silent, I thought that still he is acting as a partner. Now I am one of the person who doing or transacting the business with him. Later only I comes to know that he is not a partner. Okay, now he is liable to me. Okay, so the reason is, when I asked, are you acting as a partner in the firm? He has not yet given reply. Since he was maintained silent, I thought that still he is what? Acting as a partner for that firm. So there are various relationship of partners to third parties. These are the major important points. One is within the scope of the business. Second one is effected in the usual way. Third one, how the third party involved in the transaction. Either knows or believes the partner is acting as a partner. Point number two, unaware of any lack of authority. Lack of authority means what? Even the non-partner also who is believed to be a partner. Liability of partners to third parties. If this situation prevails, the third parties are believing that point number one, acting as a partner. Point number two, unaware but he is not acting as a partner. So what type of liability which will be goes to him? Okay, now liability of partners to third parties. Liability of a partner for acts of the firm. So these partners are liable to third parties for acts of the firm. Liability of the firm for wrongful act as a partner. So I have told already, the partners who are not yet given immediate reply, I thought that he is acting as a partner. Since his wrongful act, he is liable to me. Third point is liability of the firm for misapplication by the partner. Liability of the firm for misapplication. So three important points: acts of the firm. Acts of the firm means wrongful act of the firm, or wrongful act of a partner. Third one is misapplication by partners. And the last one, now we are going to discuss dissolution of firm. How this partnership business comes to an end. So dissolution by agreement. As per section 40, dissolution by agreement. All partners, while giving the consent in accordance with the contract among partners, the business comes to an end. It is called as dissolution of what? Agreement. Section 40. Second one is compulsory dissolution. Section 41 states that compulsory dissolution, when the partnership business which comes under compulsory dissolution means if all partners becomes insolvent, not able to pay the debts, or when the business becomes illegal, okay, then the compulsory dissolution as per section 41. First one, dissolution by agreement, section 40. Point number 2, compulsory dissolution, section 41. Point number 3, dissolution on happening of some event, section 42. Dissolution on happening of some event, either death of your partner comes to an end, expiry of term, that partner comes to an end, or completion of the ventures. There are two business where they entered into a joint venture for the completion of one partnership business for 1 year. Once the term completed or the completion of the project, business comes to an end. Dissolution by notice, section 43. Okay, in case of partnership by will, I have told already. Okay, the partners, those who want to retire or those who want to make a move at will, okay, then also it is comes under what? Dissolution, but for that they have to give the prior notice, section 43. Dissolution by order of court, section 44. If partner becomes unsound mind, only sound mind they can able to do the business, unsound mind means they cannot able to do the business. So for the unsound mind, as per section 44, dissolution by order of court, whereas the firm comes to an end. Partner incapable of performing his duty, even the duty which was instructed to him, but he is totally incapable in performing his duty also. What? Dissolution by order of court. Misconduct by the partners. Okay, so there are major 5 endings. One is dissolution by agreement, section 40. Compulsory dissolution, section 41. Dissolution on happening of some event, section 42. Dissolution by notice, section 43. Dissolution by order of court, section 44. So all these are all called as modes of dissolution of firm. Now in Indian Partnership Act 1932, we have discussed about the definition, then characteristics, then the various types of partners, and the next point is advantages, rights of partner, then duties of partner, liabilities of partner, how the partners are liable to the third parties, and at last we have discussed about the modes of dissolution of partner. So as per today's session, in business law, unit 3, Negotiable Instrument Act 1881, nature and request of NI Act, transfer of negotiable instruments, and liabilities of partners we have discussed, holder in due course, holder, and various types of negotiable instruments, negotiation and assignment, including dishonor we have discussed. Last one is discharge of negotiable instrument. Later, Partnership Act 1932, meaning and characteristics of partners, formation and registration of partnership business, rights, duties, liability, and last one is dissolution of partnership firm. With this, we are going to conclude the today's session on Unit 3, chapter subject called Business Law. With the same, then we will continue with the next chapter in the subject called Business Law. Thank you.